I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are discussing the new Biden executive order relating to cross-border data transfers. As many of you know, we've been discussing cross-border data transfers for a long time on this podcast, and the issues are largely familiar to this audience. But this is new and actually has potential significant impacts for the world economy, and thus really requires us to pause for a moment as we try to understand the full implications of this order. Our past focus has been on transfers of EU data to the US, China's data or Brazil data, but now it's the export of US data. It's not how to address EU law for the transfer of data to the US while complying with US laws at the same time. It's now how do we address US laws for the transfer of data to specific countries of concern that are identified through the executive order rulemaking process. You'll want to listen because I think this executive order is a game changer in the world digital ecosystem, and the data world is about to shift. To discuss, I've invited my partner, James Denvil, to the podcast. Many of you are familiar with James. James is a frequent guest and a longtime friend of the podcast. And I wanted to invite James in particular to join because James and I have been leading a number of client engagements on this topic. So we'll be able to dive deep into the wide implications of the order. James, welcome to the podcast.
Thank you, Scott. Delighted to be here and excited to talk about this executive order and the regulations that are coming out of it. It's a big change to the data processing landscape, as you noted. And although on its surface, it looks like it may not have a broad impact once you dive in, you recognize that this may substantially impact the operations of many companies, not just those that are based in countries of concern, as we will discuss shortly.
Yeah, I mean, I want to get into all of those things, including why I think folks may think of this as having being relatively narrow and not necessarily something they need to concern themselves with, and maybe why that impression, while a first take may be accurate, but as you dig deeper in, you start to see, no, in fact, there's a much wider implications. But before doing that, why don't we just start with the basics? What is this executive order? Why is it coming at this particular moment in time? And high level, what is it suggesting the next steps are going to look like?
Yeah, so it came on February 28th, second to last day of the month. The Biden administration released this executive order that's titled On Preventing Access to Americans' Bulk Sensitive Personal Data and United States Government-Related Data by Countries of Concern. So this is coming out, countries of concern, as indicated in the executive order and some of the press releases that have come out, and also the regulations. It's China, it's Iran, it's Venezuela, it's Russia, it's Cuba. It's countries that we would typically view as adversaries, North Korea included there as well. And there have been some concerns, particularly with the globalization of the economy and the reliance on Chinese suppliers and outsources and the increased popularity, particularly of some Chinese apps in some ways. There have been some concerns raised on both sides of the political spectrum in the US that some of these data programs may involve countries of concern accessing sensitive data about US persons or US government authorities. So the executive order is designed to address some of the global political concerns about certain countries that are not perceived as allies at the moment being able to obtain large amounts of data, sensitive personal data about US persons or about government officials because of the potential to use that for malicious or surveillance or other purposes that may compromise national security.
So to dive deeper into what you just described, James, including the title of the law, I think you said it was the executive order. It was designed to prevent the access to bulk amounts of sensitive information relating to U.S. persons by countries of concern. Now, the great thing about that phrase is you'd say, all right, well, that's what, 10 words, 15 words. Each one of those are defined terms in the proposed rules. And some of those proposed rules provide really lengthy definitions and thus could have sweeping implications. But before we do that, importantly, you're framing this, and the way that I think the executive order frames it is different than what a lot of us do in our day jobs. Importantly, we spend a lot of our time thinking about things from a privacy perspective, from a data protection perspective, or from a cybersecurity perspective. And this executive order gets at it from a completely different angle, and that is a national security perspective. And so while we're talking about, quote, sensitive personal data, in which we should figure out what is that category and how sensitive that data is, because I'm not actually sure if that's sensitive. But putting that aside, we're now talking about privacy as a national security related concern. Why?
Well, it's not an entirely new way of framing it, although we haven't had to focus on it too much. I mean, at times when Europe has disrupted transfers of data to the United States, such as under Privacy Shield or the Safe Harbor framework, there were concerns that the US government could access personal data of EU individuals without the appropriate controls in place. Now, that wasn't so much about a national security concern as opposed to just concerns of government access more broadly, and maybe the concerns about government access in light of a fundamental right to privacy. Here, though, we can see that maybe concerns about at one point there were some apps that displayed where people were working out and exercising. And some people figured out, oh, if you know enough, you can figure out where military bases are because you can now see where certain people are publishing their workout activities. You now are seeing where there are military bases, not just in the US, but also around the world. You also might think that maybe that if a foreign government that is maybe not aligned with our interests could collect a lot of sensitive consumer data, they could use that in ways to propagate misinformation, maybe to execute attacks on individuals, social engineering for phishing attacks and the like. So it's this concern, I believe this language is even used in the EO, it's the weaponization of data. Or as I've heard some people talk about, in the past, we've been used to sort of dual use products or technologies, meaning there are certain things which can be used for one purpose, but also used maybe for a more military or national security purpose. As some of the conflicts in recent times are showing, drones may be one of those items. You could use a drone just to take some pictures of your favorite golf course or your vacation spot, but we're also now seeing how drones can be weaponized. There are now concerns that personal data, whether it's data about government officials or whether it's data about consumers, could also be weaponized in ways to compromise national security.
So your point was well taken that national security has always been a frame of what it is that we're talking about. But obviously the issues that we dealt with post Schrems and the European data transfers was almost kind of the tension between the fundamental right to privacy in the EU that we were trying to protect versus the legitimate national security concerns that many governments have. And so that was that balance. In this case, while we're going to ultimately probably find ourselves coming up with privacy-oriented solutions, those privacy-oriented solutions are not intended to really protect people's privacy. That may be a byproduct, but instead what we're actually trying to protect is a national security-related concern. And that national security-related concern is going to be driving the protections that need to be put in place that, while helpful for privacy, while helpful for cyber, will be intended to achieve a different purpose.
Yeah, I think that's a really good point, Scott. So one of the big differences here is opposed to a privacy framework where you're going to impose the same set of controls on a certain processing activity, regardless of who the recipients may be, where there's contractual provisions, anonymization, privacy enhancing technologies, whatever those controls may be to mitigate privacy risk. Here, the one and the same transaction where the only difference is whether the recipient is a country of concern or subject to the control of a country of concern, as opposed to the recipient being established either within the United States or with an ally or subject to the jurisdiction of a more allied framework. You do not need the controls. On the one hand, if it's a friendly recipient, quote unquote friendly, no, this EO does not require anything, essentially. Whereas if it's a country of concern or an entity that's subject to the jurisdiction of a country of concern, you may be prohibited from engaging in that transaction or may have to impose robust security controls on top of it.
Yeah, I mean, and that's super important, right? Because if you think about the implications for this, it's not going to affect transfers to the United Kingdom or transfers to France or transfers to Italy. What this is going to go back to is saying we need to have specific protections for specific types of transfers to specific countries. You named them earlier, right? That list is maybe going to be obvious ones, which may not really have that much effect because there are already existing sanctions in place. Probably things like Iran and North Korea and Cuba. But it doesn't stop there. It also includes Russia, which, we've been dealing with Russian sanctions for the past couple of years, ever since the onset of the Ukraine-Russia war. Venezuela is also on that list, but importantly, right, that one of the ones that you mentioned is China.
Right, including Hong Kong and Macau. So not just China, mainland China, but also Hong Kong and Macau.
Right. And as everybody, who's operating multinational global businesses know, is that there are a number of data transfers in the ordinary course between the United States and China in order to do all sorts of product development or supply chain. There's employee relationship. There's all sorts of connections between those two countries. So doing anything that's going to essentially say we're going to stop transfers of data from the US to China in particular would be extremely disruptive. Now, importantly, that's not what the proposed regulations say under the executive order. I think the executive order itself doesn't necessarily require anything. So to think about where we stand right now, the Biden administration releases this executive order, much like many of the other executive orders, including the one that we saw recently relating to AI. It requires government agencies to be able to release a number of regulations that are going to implement the policy objectives that are set out in the executive order. What was different about this executive order versus perhaps one of the ones that we saw with AI is that the Department of Justice, which is one of those agencies that was called upon to make the rules here, simultaneously or contemporaneously released an advance notice of proposed rulemaking, which are not the definitive regs or even the regs that may be in their final form, but gave a very clear indication about what the Justice Department is thinking is going to be subject to these requirements and which ones we think are not going to be subject to these requirements. And really created this paradigm, I think, of not only identifying those countries of concern that we went through a moment ago, but also identifying proposed transactions, proposed types of transfers that will be straight out prohibited, can't do them anymore. And then ones that you can still do, but you effectively have to have a number of compensating controls to restrict how access to that data may be granted or may become accessible to those countries of concern. So maybe, James, interested in your perspective of how you're thinking about those two categories. Let's start with, hey, you can't do these transactions anymore. They're straight out prohibited.
Yeah. So as you said, the EO, the executive order, it directs Department of Justice, along with some other agencies, to issue regulations within 180 days, essentially. So come August is when we'll see the first real draft regulations if they meet their timelines. But at least now we're looking at this, advance notice of proposed rulemaking where DOJ is asking for comments essentially on the way it's thinking about and indicating how it's thinking about these regs. And as you noted, two classes of transactions. There's going to be prohibited and there's going to be restricted. So let's start with prohibited. The types of transactions that are going to be prohibited are if you're disclosing bulk quantities of human genomic data, so genetic data and the like, if you're disclosing that to a country of concern or to an entity that is subject to the ownership, control, jurisdiction, or direction of a country of concern, so think an entity located in one of those countries of concern. So bulk genomic data, that's out of the picture, or genomic data, genetic data related to government officials. Or, and this at first sounds like it's going to be pretty superficial, data brokerage transactions where you're sending bulk US sensitive personal data to an entity. You're engaging in a transaction, whether it's bulk US sensitive personal data, and it's a data brokerage transaction. And the recipient is either a country of concern or a covered person, which is one of those people who is subject to the jurisdiction of the country of concern. So I'll stop there, but that's what it is that is prohibited.
Yeah. So that prohibition category, which I think is the narrower of the two, right? Because I think there's going to be many more restrictions that are going to be quote unquote restricted, which we'll get into a moment. But think of it, if we say what is going to be prohibited, I hear, okay, I heard you say data that is subject to a data brokerage transaction.
Yeah. And only sensitive personal data when you first look at it. So it's just if you're a data broker and it's sensitive personal data, then it's going to be prohibited, which may make you think, okay, this is just the traditional data brokers of the world who are trafficking, I may be in health records, medical records, or precise geolocation or detailed financial information. And that's the extent of it. That might be your first take when you just read the high level summary of it.
Right. But that's not the right take as you start to dig into what a quote unquote sensitive personal data is, because I think that term is probably not the right term to use it, because sensitive in our privacy world means something, and it means something that we all kind of have a general understanding of, like when I know it, I see it. This, I'm not sure I know it when I see it.
Right. I mean, it starts off, I mean, parts of it, you look at it and you go, okay, I agree. This sounds like the common type of sensitive personal data, what we're seeing in the US state privacy laws or seeing in GDPR or other frameworks, genetic data, biometrics, precise geolocation, health data, financial data. But then you get this really broad category of personal identifiers. And that is when we start looking at this doesn't seem like sensitive personal data at first glance. It reads more like the broad general category of personal data, where it's got device IDs, contact information, so emails, phone numbers, basic demographic information, so addresses, advertising identifiers, so the ad IDs on your iOS or Android, network identifiers, CPNI types of information. So all of that, just a basic identifier, could now be lumped into that list of US sensitive personal data, particularly if it's linked to any other information.
While I know the FTC is greatly expanding its view of what constitutes sensitive personal information, I don't know if anyone says that like IP addresses constitute sensitive personal information, but the DOJ disagrees so long as at least that information is linked to another category. So big implications, right, about what we think of as sensitive personal data. Probably the better way of describing that is personal data that has more than one data element, in which case then it's going to be covered. And also for a moment, when we say personal data, us in the data world, we usually think, okay, well, that I get it, information that relates back to a specific individual. But when you take data and you anonymize it, you de-identify it, you take it so that it no longer relates back to a specific individual, then we're okay. Is that the case here?
Well, it's not the case here, though. It would be the case just about anywhere else at the moment. And again, this is just a notice of a proposed rulemaking, so things could end up being differently. But at least the way DOJ is thinking of it now, bulk US sensitive personal data includes any of that data we just talked about, even if it's anonymized, aggregated, pseudonymized, whatever privacy enhancing tools you want to put on top of it to reduce privacy risk, it's still going to be considered US sensitive personal data, subject to the exact same prohibition if it's a data brokerage transaction.
Okay. And data brokerage transactions and bulk, I just want to kind of pause for a moment on both of those. Bulk, We don't yet know exactly what bulk is going to mean in the end. I think they're asking for comments about how much data is too much data in order for that to be triggered to make it sure it's bulk versus kind of other types of data. What is clear is they're not trying to say that you disclose one person's information that that's going to pick up these rules. It's going to require more than that. Exactly what that is, still TBD.
Right. And what the one point there that some organizations may want to think about is even if you're only in each transaction providing one person's data, if you're engaging in enough transactions over time, particularly within a 12-month period, that it reaches those bulk thresholds, that could be considered bulk data, even if any individual transaction is not reaching the bulk threshold. They're going to look at it over time. But the issue, though, is if you're thinking, well, this is still just dealing with data brokers, and I'm not a data broker, so I don't need to worry about this. The definition of data broker more aligns what I would think with the California and the other state privacy laws definition of sale, where it's much broader than what we originally thought, where essentially if you are disclosing any of that data, the personal data, to a recipient that has the rights to use that information for its own purposes. And the terminology they say is if you sell, license, or engage in a similar commercial transaction with such an entity, where that recipient of the data did not collect the information directly from consumers, that is a data brokerage transaction. So even a vendor operating on behalf of another entity that collects data directly from a US person and then delivers it to a recipient for its own purposes, that's a data brokerage transaction under this, which captures a whole lot of intragroup, third party, even controller processor transactions that we normally would not think of as being a data brokerage transaction.
That, and I think, there are real concerns about secondary data uses
Yeah.
with this definition, right? In other words, as you enter into a number of relationships, especially when you're using things like artificial intelligence or any other technology solutions, the key is that those vendors, those providers of technology need the data to be able to continue to enhance and develop those technologies. And that's obviously a hotly negotiated item, and there are rules around what you can permit, but oftentimes you can permit uses of data for in de-identified form for that kind of thing. And one concern I have is like, okay, well, we de-identify the data, thus we allow vendors to be able to leverage this data to enhance their systems. They don't have a direct relationship back to the consumer, and they may end up providing this information to their partners, to other partners, in connection with their ability of enhancing their products. But it sounds like if we're not going to recognize the identification as a means of getting out of sensitive personal information, second, we are defining brokerage transactions as something where the recipient doesn't have the relationship back to the consumer. Boy, I feel like we're now pulling in all of the transactions where technology companies are getting secondary data rights to large amounts of sensitive information to enhance their products, which happens all the time.
Yeah, I agree. It does have the potential to be quite broad. Now, there may be some considerations where you can think, okay, this entity that's going to receive it, it's not a covered person because it's not, essentially owned by a country of concern, or it's not established or subject to their jurisdiction. However, the way global data flows work, it is going to be broader than you initially think, even if you just think straight off the bat, no, we're not, dealing with China. We're not dealing with North Korea. We're not dealing with Russia. You never know where it's going to bleed out in the ways that data is used and the way that data centers are located and the like. So I do agree there's potential for broad impact here, though, remains to be seen how they respond to comments that they receive. And there may be some opportunities to, downscale some of the impacts here. But as it's written, this seems quite broad, and we've only touched on data brokerage transactions really so far.
Yeah. Well, I mean, we'll save the conversation about the genetic information and perhaps the information relating to government contractors and government officials and government employees and military officials to a separate episode. But I would note, maybe before going over to the restricted side of the ledger, that second category relating to information relating to government officials and to military officials and government contractors, that itself is also very thorny because many times organizations have no idea who is the subject of their data, what role they have. When you're operating an e-commerce site, it's not like you include a tick box to say, by the way, do you work for the CIA? To somehow say that we're going to impose obligations with respect to that information can be tricky, and love to see kind of how that finalizes, including kind of what level of diligence is needed in order for organizations to say, that this information wasn't clearly related to a government official.
Yeah, and it does seem from the executive order and the notice of proposed rulemaking that potentially they're just focused on data that is advertised as being linked to government officials or that indicates that it's associated with government officials. However, as we've seen, not just in the US, but broadly elsewhere, given the potential for technologies to reveal certain information with AI, big data tools, and the like, and if definitions aren't precise, and if they're left to broad interpretation, there's always the potential for some regulation that is intended to be somewhat narrow to on its face actually have a broad applicability because they didn't foresee the potential for technology to actually now start to indicate that data is associated with a military individual, even if no one's really trying to market it as such.
All right, so that's the prohibited side of things. And as I said, well, I have grave concerns around even how broadly those things are defined. They're not in anywhere, even in the same universe as the potential implications for what it looks like on the restricted side of the house. So restrictions, like there are implications or requirements for that any type of transaction that involves that transfer of bulk sensitive information, either through a vendor relationship, an employment relationship, or an investment, related agreement, will now fall in the camp of restriction. In the way that I think about this, it's almost like, well, those transactions are prohibited unless you do something to make them permissible. And so let's kind of toy around with that framework in a moment, but first start with, what does it mean to enter into a vendor relationship, an employment relationship, an investment relationship that will involve the access to bulk amounts of sensitive data?
Well, you use the word involve there, and that is the one that's used in the EO and in the notice of proposed rulemaking as well, the advanced notice of proposed rulemaking. So it's broad. And in the DOJ's notice, it focuses on, it's not just actual access, but if there's potential to access. So let's say a vendor agreement. If you have a vendor that's processing certain data for you, or maybe performing some cybersecurity operations or some kind of IT troubleshooting operations, if they just have the possibility of maybe being able to access some data repository that contains bulk US sensitive personal data, that would be the type of vendor agreement that would be subject to the restrictions under this law, meaning it's prohibited unless you do a bunch of stuff that we'll talk about in a bit. Same with an employment agreement. If I employ someone in a country of concern, let's say, a foreign person who's resident in a country of concern or maybe subject to their control in some way, their mere potential to access it means that I'm going to need to do certain things. Otherwise, that employment agreement may be prohibited. And then with investment agreements, if that joint venture, if that joint investment in a startup, whatever the investment is, and it's broad, we're not just talking about financial transaction investments, but we're talking about any kind of investments in an entity where some entities end up having control over some entity. If one of the entities that has control is subject to the jurisdiction of a country of concern and could use that control to gain access to bulk US sensitive personal data, that would involve that data and therefore would be prohibited unless you put the controls in place.
So, I think that would be then very clear, right, as to why this category could be so much broader, including, let's just take a step back and say, do organizations fully appreciate at this moment who in their supply chain, who in their investment structure, even potentially who amongst their employees would fall in the category as being subject to these requirements, being subject to the jurisdiction of a country, the laws of a country of concern, being owned by the nationals who are citizens of those countries of concern. There's a seemingly large information gap to try to determine how these rules would apply.
Right. And it seems like, at least DOJ states, they want to focus on whether you knew, but there's a couple of times where they mention should have known, which suggests that diligence may be required. So if I hire a remote worker, I think maybe they work in France. Maybe I need to engage in some diligence to figure out where they really live or where they're going to move to later on and still perform work for me. If I'm onboarding a new vendor, maybe they're based in the US. Am I going to have to conduct diligence to find out about their ownership structure, who their major investors are, before I go forward with that vendor agreement? It may on its surface be a US-based company or a UK-based company that I have no concerns about. But there is some suggestion, if it's a should have known standard, what is going to support that should have known? Is it undergoing the reasonable diligence that any company should, in the same way that you may do diligence for privacy and cybersecurity? Do you now need to do diligence for coverage by countries of concern? And the same with any investment agreement. When you're partnering with some firm to invest in a startup, let's say, how much diligence do you need to do with your partner to make sure that they're not, actually a proxy or a distant connection to a country of concern where maybe there's potential access? So it could be quite broad and engage, a requirement for substantial diligence.
I think that's right, James. And I think it's important to make sure that we're also bringing in the broader picture here, because the DOJ expressly, and I think even the executive order refers back to that they are leveraging the same type of framework and concepts that are included within OFAC for sanctions related purposes. And, much like organizations are advised to be able to conduct appropriate diligence against organizations to determine that you're not paying or entering into some transaction with a sanctioned person, I can't imagine that even if initially the government thinks of this as knowingly, that's going to last very long before they say, also, you can't hold your head in the sand. And, the ostrich strategy is only going to be so effective, such that I think the real implication of what it is that we are talking about now is that the data related ecosystem needs to have a level of transparency and accountability and specificity than it ever has had before, just to understand to what extent the individuals involved in that are going to be subject to this order. And that is a level of clarity that I think is largely absent in the data related world today. Do you disagree?
I do not disagree whatsoever. I think that is spot on. And I think I would not be surprised if these rules go through, and even, if there is a change in administration, if they continue to go through the rulemaking process and how they turn out. They suggest that there will be lists of at least natural persons, individuals who would be considered covered persons subject to the either prohibited or restricted transactions. I wouldn't be surprised for there to be entity lists that come out as well, where maybe don't need to do intense diligence of the actual company, but maybe at least you have to consult sanctioned entities lists like we do now under OFAC and others.
Yeah, I mean, be very interesting to see how that plays out, and what do we think is actually scalable or workable in this space. But let's also make sure we hit the other portion of this. So, as I laid out the framework, right? These transactions, vendor transactions, investment transactions, employee related transactions that will involve the access or the potential access to bulk amounts of sensitive information are prohibited unless, right? That unless is that key component. What is the unless, and where do we and how much clarity do we have around what you need to do to avail yourself of that unless exception?
So the unless exception is not entirely clear at this moment, partially because it will be DHS that's responsible for issuing the specific security requirements that will support or authorize these restricted transactions. But the ANPRM does suggest what those could include. It could be having a security program in place that's based on something like CISA's cybersecurity performance goals or the NIST framework. It'll be implementing basic organization and cyber requirements, mainly focusing on limiting access to the covered persons and making sure that you've got documented policies and procedures in place to prevent that access, and risk assessments and monitoring and revising the program as needed. Data minimization, privacy preserving technologies, logical and physical access controls, maybe even compliance certifications, maybe even third-party audits of your cybersecurity plan, potentially with reporting obligations as well. Certainly, at least with documentation and having to hand over the documents upon request. But that's the kind of framework that DOJ is suggesting, subject to further clarification from DHS once it has its rulemaking activities underway.
Right. So maybe thinking about it even broader it's a cybersecurity set of controls and set of standards that you will need to meet to effectively give some level of comfort to the US government that a country of concern won't have access to this information. In other words, I still engage this vendor, which was based in Venezuela, but we put in these controls such that that vendor wouldn't be able to gain access to that data. Now you may say to yourself, okay, well, but let's just not lose sight of the fact that we've been engaged in this tacit campaign amongst cybersecurity professionals, which is between some of those countries on that list who are engaging in cyber activities to gain access to that data, right? To effectively try to be able to gain that data that anyway, even if you didn't grant them access. So what this is now saying, you have to put in these controls that are going to prevent those cyber related attacks. I mean, that's a standard that probably nobody can meet. So it's got to be something less than that.
Yeah, and it's a weird shift in the framing of a cybersecurity program, I think, where cybersecurity now is understandably, we are protecting data against threats from certain outside parties, setting insider threat issues aside or, negligence aside. But there are outside parties who are targeting us. So we are going to put up a system, a set of controls that are designed to protect against that deliberate activity. Now it's kind of going a step further where it's not enough for me to, I want you, Scott, to be performing some service for me. So I assess you and I think, Scott's a reasonable, compliant guy and seems responsible and I have no worries about him. So I'm going to allow him access to the data. But that's not enough now. It's not just whether you are considered a reasonable person to access the data or a safe entity to access the data. I also have to look at what government has its hooks into you by some kind of jurisdiction. So you may be a perfectly sound, reasonable person to access the data, but I've got to look beyond to what could somebody else make you do. And that's going one step broader than we typically think about with cybersecurity.
Well, James, I know we need to wrap here, and I feel like there's so much more that we can dig into, and I'm sure we'll have opportunities as this set of advanced notice of proposed rules making goes to the actual proposed rulemaking, and then figuring out how things are going. But I mean, as I'm thinking about what the challenge here is, which, from a national security point of view and from the government's perspective, understand that quite well. But from a company's perspective and from, the entities who are actually going to be subject to these requirements, I'm hearing basically, every word on the data protection hit list. It's going to be part privacy. It's going to be part cyber security. It's going to be part it's going to be part data governance. It's going to be part program building. It's going to be part third-party risk management, vendor supply chain management, access controls. I mean, I'm trying to see what areas it doesn't cover as opposed to what areas it does, and it feels like we hit them all. Thus, if this takes shape in the way that I think the DOJ is signaling, and I think, they're not even going to have the last word because there's other agencies that are also going to be part of this rulemaking process too, that we are really need to think about this as a seismic shift in the way that US data can move across borders and be part of the larger global data ecosystem, at least for those quote unquote countries of concern.
I think that's right. And sort of my closing thoughts about it are, although you will read in the EO and in the DOJ's advance notice of proposed rulemaking that we're not trying to upset global commerce, that there are going to be exceptions for certain, transactions that are ordinary and incident to normal business operations, including some financial exemptions, and there may be some licensing of certain data transactions. So they're trying not to disrupt global commerce. On at least that's what they said on their face. Given this fairly rushed timeline where we're now going to have comments due by around, April 14th of this year on the advance notice for DOJ, they're supposed to issue their at least first round of draft regulations by mid-August. And as you said, there was a number of issues that you just laid out there, and we haven't even touched all of the issues in this podcast. And somehow we need to come up with a thoughtful, reasoned framework that addresses these thorny issues of national security without disrupting global commerce and day-to-day business operations. It's going to be quite a challenge.
Yeah, folks who are interested in this space, which I think everybody should be, should stay tuned to this podcast. We'll keep you updated as we start to continue to hear things that are more, in the meantime. I think at the moment that the opportunity is to prepare, because this, I think, is going to take a lot of work to try to understand how these rules are going to apply. How in the world are we going to then try to come up with a strategy to comply with them? And, as you said, James, the rushed nature of this, especially with the fact that the government is not inclined to extend out these timelines, given that we are trying to address a national security concern, I think is going to mean that the opportunity is going to be more of a short-term opportunity to get out ahead than feeling like you have to react. With that, James, thanks so much for joining the podcast. Looking forward to future conversations relating to this executive order. I'm Scott Loughlin. This is the Data Chronicles, and those are your data points.